Well, welcome. My name is Dexter Bradford. I'm an employment law attorney here at Beresfrod Booth. And today we're going to be talking about all things employee handbooks. I know the title says the new employer's guide, but this is not just aimed at new employers, whether you're a new employer thinking about maybe getting your first handbook, or you're an employer that's been around the block a few times and you haven't updated your handbook in a while. There's some drafting tips we're going to talk about and some recommendations, as well as some common mistakes seen in employee handbooks. So if you've already got one, stick around. You might find some of these tips are applicable to you. If you've never put one together before, this will be very helpful. And let's get rolling. So what we're going to be covering today is first, whether or not employee handbooks are required. Are these a document that you need to have as a company? Are they helpful, and why are they helpful? Top 10 mistakes that I see in employee handbooks. There are much more than 10, but these are the most common and kind of reoccurring mistakes that I see kind of over and over again. We'll talk about some specific employee handbook requirements, stuff that you absolutely have to have in there. And then some general recommendations if you're putting one together. So first and foremost, are these even required? What is an employee handbook? Do you have to have it? If you're a new employer, you're probably, you know that you're probably supposed to have one. You don't know if it's legally required or not. Everybody of places you ever worked at usually has one. So what is it? Do you need to have it? No, it's not legally required that you have an employee handbook, but if you want to keep your sanity, it kind of is. An employee handbook is going to have a bunch of policies that you have to tell your employee. And now the law doesn't require that you have to have an employee handbook, but it does require that you have to notify your employees of a bunch of different policies. So unless you want to figure out a way to make it clear to every single employee that these are the policies, or email them every single time you get a new employee, or find some other way to do it, you can try. Is the employee handbook the best way to do it? Absolutely. Just have an employee handbook. It's basically a requirement if you're going to have employees. So why might you want one, other than the fact that it's legally required, not legally required, but you're going to want to have those policies covered? Why else would you want one? Well, first of all, it's a valuable resource for employees. Employees want to be able to get a taste of what the company culture is going to be. Being a new hire at a company is a stressful event. You're walking into a new work culture and you're not sure what to expect. Having a well-drafted employee handbook can give the employee a good first impression of your business and the policies and how it's going to be run. It's a good opportunity for you to tell that employee, this is how I'm going to run my business. This is how things are going to be if you're going to work here. It also creates positive outcomes for employees and guidelines for them. So you're also giving that employee an opportunity to understand, these are my expectations. It's going to tell the employee, this is what you're going to be required to do. This is what we're expecting of you. And this is what we'll be giving you in return, sort of like this is what we'll be provide, the sort of culture we're providing you with. And that makes life a lot easier for employees when they have clear expectations and guidelines. They know what's required of them. You're going to run into less problems because employees know how they're supposed to act. And then finally, it also creates certain protections for you as an employer. That's probably the most important one for you. If you're listening, then it's going to create a bunch of additional protections for you. It's going to help you avoid a litany of different problems and potential lawsuits. So let's get into some of my favorite mistakes when creating employee handbooks. These are stuff that I see on some of them on a regular basis. Some of them are a little less common, and they're not in any particular order. But this is a very important one right here. Taking a boilerplate approach. This is one I see very common mistake. You're a new employer. You want an employee handbook, and you go online and you Google employee handbook, you find the cheapest one you can find, or maybe a free version, you download a template, and then you just slap your name on there and call it a day. Don't do that. If you're watching, you will promise me right now that you're Dexter, I am not going to go online and download a boilerplate employee handbook and have that be my handbook. It is not the correct way to do this. It's a terrible idea. One, because who knows if they actually have all the legal requirements that are supposed to be in there for you. Maybe, maybe not. Second of all, it's not even reflective of how you want to run your business. Like we talked about, this is a great opportunity for you as an employer to say, have a document that says, this is our company culture. This is our company Bible. These are our policies. This is how we operate. This is how everybody's going to get along. This is how we're going to function as a business. And then if you just take something online and then you download it and you print it right there, you're just taking somebody else's idea of how a business could be run. And then you're saying there it is. So not only is it not really reflective of your company cultures, but it's also going to be confusing because new employees are going to read that and think that your business is going to be run one way and then maybe you're doing something different. And then again, who knows if it actually covers all your bases, because employee handbooks, as we'll see, they have certain requirements and there are some certain pitfalls that you can fall into as an employer if you don't have the correct provisions in your handbook. Odds are that a boilerplate one off the internet isn't going to have all the correct provisions in it. All right, next up, not including all policies in the handbook. So if you have a policy, this one's more for employers who have a handbook already, but like, let's say you have an employee handbook and you have some policies that you listed out there. Your business is constantly changing. All employers know that you have people coming and going, you have policies that are going to change, and oftentimes what will happen is you'll put in a memo, maybe here's our new policy, we're going to do this differently, but then you don't update your handbook. If you're creating a new policy, whether it's changing an old policy, creating a new one, changing your business, those policies deserve to be in the handbook. If you're going to put it in writing and tell it to all of your employees, just put it in the handbook. The next bit, and this is a big one, is omitting disclaimers. And specifically, I see this one all the time. It's such an easy, simple thing to do, and it gets left out all the time. I'm talking about, there's a disclaimer that I always include and should always be included at the very top of your employee handbook that simply tells the employee that this is not an employment contract. It is just an employee handbook, and it's not changing your status as an employee. So just to, it would be a side tangent just for a second, we're going to talk about employment status. I won't go super deep into it, but unless you are living in Montana, every state in the United States, every employee is presumed to be an at-will employee. That means they can quit at any time and you can fire them at any time for any reason, as long as it's not a protected reason, but we won't go down that rabbit hole yet. But for the most part, you can fire them for any reason at any time, and they can quit at any reason for any time. That's an at-will employee. Now, they're all presumed to be at-will employees. Like if you're here in Washington, you get hired onto a job, you're presumed to be an at-will employee. But an employer can change that, and they can make you a contracted employee. They can make you an employee who can only be fired for a certain specific set of reasons. And employers can sometimes inadvertently change that. And you don't want that as an employer. You do not want to inadvertently change an employee's at-will status to now you can only be fired for a certain set of reasons, because now you have an employee that you can't fire unless one of those reasons are met. Now, so it helps to set up up front, just have a line at the top of the employee handbook that says this is not an employment contract. Because if you make specific promises to an employee, and there are specific promises about their employment and what you're going to do, then that employee can sometimes rely on your employee handbook and say, this is a contract. I'm not an at-will employee. I have a contract with my employer, and it says that they're not going to fire me unless I do X, Y, or Z, or for these reasons. So sometimes you can inadvertently create an employment contract through an employee handbook. And is a disclaimer going to be sufficient? If you just say at the top, hey, this is not an employment contract, absolutely. In Washington, yeah, it's totally fine. If you just say at the top, this is not a contract for employment, then your bases are going to be covered. So I cannot stress it enough. I see it missed all the time. It's just a paragraph at the beginning that's going to say this is not a contract for employment, and you can get out of a world of hurt and a world of headache, because you don't want to find yourself in the situation where you've inadvertently created a contract with an employee you had no idea, and now you can't get rid of them or they're suing you. Next up is an overly restricted confidentiality and social media policy. This one's a little less common. I wouldn't say this is like a super common mistake, but something that I've seen as social media has become very prevalent and a bit of an issue for employers, with potential for employees to badmouth their employer or their job. Some employers have taken the approach of drafting highly restrictive social media policies, and by that I mean a sort of social media policy that's like, hey, you can't post anything negative about your employer on social media. You can't say anything defamatory, or you can't say anything even remotely negative about us. You're running into some employee rights issues there if you have an overly restrictive policy like that. And it's best practice not to do that. I would say that a social media policy should be in your handbook, but it shouldn't be so overly restrictive that you're like taking away the free speech of your employees. You kind of want to avoid that area. So you should have one, but it shouldn't be so overly restrictive that they can't say anything about your company. Unfortunately, you can't stop your employees from saying bad things about your company. If you can fire them, but if they're not happy there and they want to say that your company sucks, they have the right to do that. Trying to take away that right, you're going to run into some problems. But there are some different approaches that you can take to sort of alleviate the pains of having employees post on social media. So there's a couple other approaches that you can take, but don't take that overly restrictive approach. Next up, we're going to talk about not having an effective anti-harassment policy. This is a big problem. It's not the most common problem, but it's a big problem if you don't do it correctly. An anti-harassment policy is probably the most important policy in all of your employee handbook. Harassment is a big issue in the workplace, and it's a big issue for lawsuits. It is how you're going to get in trouble. It's how you're going to get slapped with a big, huge lawsuit if you don't handle harassment properly. So having a well-drafted, well put together harassment policy can save you a lot of money and a lot of time. Harassment policies don't need to be, they don't need to be super overly specific. By a well-drafted, I don't mean one that's 20 pages long that's going to tell you every single step that we're going to go through if harassment is reported, because an employee doesn't need to know all that. But what they do need to know is that you have a policy that is going to deal with harassment. It's going to define what harassment is for the employee. It's going to tell them what it is and what they should do about it if they've encountered any harassment in the workplace. That's what you need to have covered so that the employee has at least a guideline for here's what's going to happen. And again, that is a big issue and can be very, very expensive if not handled properly. And then this one is a more also pretty common, but less as big an issue as the harassment policy, and that's just being user friendly. Sometimes these can get a little wordy or a little too legalese, and this is ultimately a document that's it's here to protect you, but it's also to be a guide for your employee. Most employees don't want to read 100 pages of legalese, and they're not going to. And what good is paying for and putting all this work into an employee handbook if no employee is going to read it, or if it's going to be completely unreadable? So make it more user friendly. I want to, I like to have some sort of color or the paragraphs, table of contents. Make it as easy to read as possible for the employee, and to try and be concise. It shouldn't be a 100-page document, a 50-page document. It should be 15 to 30 pages max, and something that the employee can easily read before their first day. So I think I skipped through a couple there. So next up, we're going to talk about failing to train. This is an issue for larger employers. Well, not larger, but people who have employee handbooks, who have managers. If you have managers, make sure that they're trained on your policies. There's nothing worse than putting together a well-drafted employee handbook. You put all this time and effort into this beautiful handbook that dictates exactly how your company's going to be run and all your policies, and then you forget to train your managers on it. And the manager doesn't read it, and then the manager, without your knowledge, is managing and doing all of these things and implementing new policies that are not in alignment with your employee handbook. It's going to create all sorts of problems and a lot of confusion for your employees. It's difficult for an employee to see, that it's supposed to be run one way and it's actually being run another way. And that's oftentimes in larger companies, the disconnect happens between the owner and some mid-level or senior manager that, maybe didn't read the employee handbook and has their own ideas on how the business should be run. And sometimes that disconnect can cause some problems with lower level employees not knowing what to do. And in that same vein, applying policies inconsistently is also a big issue. If you've got an employee handbook, stick to the employee handbook or change the employee handbook. Don't just again grab something off the internet and then say these are our policies and then do something completely different. For example, I got at a previous job, they gave me an employee handbook before my first day. I read the employee handbook. It wasn't super long. It wasn't super well drafted. And now I know that it was very out of date. And they had a policy on there that said that on every Friday, it's casual Friday. Everyone comes to the office in casual wear, and they defined what casual wear was. You could wear jeans and a t-shirt. So I came to work on Friday. I thought I didn't want to be the only guy, dressed up. So I came to work in my jeans and a shirt, and lo and behold, nobody does casual Friday. And my manager came up and was like, "Hey, what are you doing? Why are you dressed like that? You can't, you got to wear a suit, or you got to wear, at least a shirt and tie every day. This is not, we don't do this casual Friday thing." And I was so confused. I was so embarrassed because I was like the only guy at work who's wearing jeans. And but it was frustrating because it wasn't my fault. I read the employee handbook, and the employee handbook told me one thing, and then I show up to work and company culture was something else. So if you're going to have a policy on there, at least just make it up to date and avoid the confusion. Obviously, that way, wasn't a big issue, but it can cause some bigger issues if you have some policies that aren't in line with how you actually practice. Next, we have overly restrictive disciplinary policies. This is sort of in that same vein of having an overly restrictive social media policy. It's similar to that. So what we're talking about is avoid having a disciplinary policy that kind of locks the employer into a certain set of standards. And what I mean by that is sometimes what I'll see is a handbook that'll say employer has to do X, Y, and Z, and or a big numbered list of this is exactly what we're going to do for any sort of disciplinary action. We're going to take this step, and then this step, and then this step, and then this step. And the problem with that is it sort of locks you as an employer into this bubble. And for every single disciplinary action, you've got to do all of those things that you said you were going to do. And if you've been in business for a little while and you have employees, you know that every single disciplinary action is its own beast. It's its own thing. And so you can't have the same rigid set of standards that you're going to do for every single disciplinary policy. What you need for yourself as an employer is a little bit of flexibility. So it's similar to that social media policy or that or the other policies in your handbook, that you want to have it to be specific in terms of you're going to tell your employee that we will handle discipline, and this is how we're going to handle discipline. But you want it to be flexible enough that it gives you the flexibility as an employer to take it on a case-by-case basis, and to have discipline be handled, in its own case. So that way you're not stuck to this rigid set of standards. And then finally, and I know I said there's no order, but this is the most important one, is failing to keep your legal team in check with everything that's going on. If you have a legal team, like an in-house legal team, CC them on everything. Why would you not? Absolutely keep them involved with 100% of the policy changes, employee changes. Let them know about everything going on in terms of hiring and firing employee, policy changes, harassment changes, harassment reporting, any of that stuff. They need to know immediately. If you don't have an in-house attorney, call me, talk to me. I will talk you through all of these issues. I'll talk you through, the changes to your handbook. If I've done your handbook, I'll tell you what changes need to be made. If there's any legal changes that need to be made, if you're making changes to policy, if you find yourself writing a memo and you're writing this memo about how you're going to do things differently at your business, you're changing the policies. Just give me a ring. I can change your employee handbook for you, or you can change it yourself, but consult with an attorney if you're changing anything. There are a lot of different requirements that we'll see in a second. And you don't want to find yourself in a situation where you're accidentally not in compliance with some sort of law or regulation anymore. So let's talk about a few of the handbook requirements. There's some specific federal requirements, and then I'm going to talk about some Washington requirements. You should be aware of the fact that there's requirements in each state may have their own specific set of requirements. Sometimes they overlap, sometimes they don't. Some are wildly different than other states. And so it's important to keep in mind what your zone of coverage is. What states are you going to need to be in compliance with, and are you in compliance with those states? But for the purpose of today, I won't go over every single state's employee handbook requirements. That would be mind-numbingly dull, and you'd be out of here in a heartbeat. But I'll just go over quickly federal law requirements. You're going to need an equal employment anti-discrimination policy, FMLA policy if you're 50 employees or more, jury duty leave, military leave, and sexual harassment policy. The Washington ones you'll see will overlap a little bit. You've still got FMLA, jury duty, military leave. And then you'll see in Washington, there's some area specific laws, like the paid sick leave has specific policies for Seattle employees and Tacoma employees. And some policies are required on different numbers of employees, like pregnancy and disability leave, and the volunteer firefighter and civil air patrol leave one. And so if these are policies that you're lacking, you'll need to probably consult with me. Give me a call. I'm happy to help you get these policies and make sure that your handbook is in compliance with the requirements. And then some general recommendations. First one is stop using probationary periods. I see these all the time. I guess this is maybe another mistake, but it's also a drafting tip if you're putting one together, is don't have a probationary period in there. I see these a lot, and what they usually function as is you'll see a provision in there that says that this employee, or as a new employee, you're on a probationary period for 30 to 120 days, usually is how it's drafted. And sometimes it'll say that the worst ones I've seen say something along the lines of like you are in a probationary period, and you can be fired for any reason during that probationary period. Your probationary period ends after 120 days or 90 days or whatever the time frame is. And then your benefits will kick in. Employers usually do that because they want to delay benefits, and usually because in their mind, they want some sort of control over a new employee. They want to see if this employee is going to actually work out or not, if they're going to be a good fit. And if no, they're not going to be a good fit, they just want to get rid of them early on. The mistake is every employee is presumed to be at will. Remember, we talked about every employee, unless you're in Montana, you're going to be an at-will employee. You can be fired at any time for any reason. So you don't need a probationary period to fire that employee. The worst part is by telling the employee, hey, you're on a probationary period and you can be fired for any time during these 120 days. And then after that, sometimes they don't say anything, or sometimes they say you'll be a full-time employee, or you'll be considered a full employee, or something like that. That doesn't really have any meaning. Then if that person gets fired and they go talk to an employment attorney, that employment attorney is going to tell them, hey, we're going to argue now that you were not an at-will employee after the probationary period. And they're going to say, well, since they said you could be fired at any time for any reason during that time frame, and you got past that time frame, well, that must mean that something changed. That must mean that you're now an employee that can only be fired for a specific set of reasons. The argument's not always successful, but it's there nonetheless, and you don't really want to find yourself in a situation where you've accidentally again created an employee that you can't fire. And so just don't include these probationary periods, because also as an employer, you're not getting any additional benefit from this. You can fire an employee at any time for any reason anyway. So by telling them you can be fired during this probationary period, you're not protecting yourself from anything. So if you want to delay their benefits, there are other ways to do that. But the whole probationary period thing is kind of a thing of the past. And I always recommend just sort of taking it out of there to avoid any sort of hassle down the road or confusion later on. And, it's not providing you with any benefit. And then last one that I'll talk about is pay attention to remote employees. I mentioned earlier that employees in other states can cause problems. And especially with the change after COVID, all these remote employees working everywhere, your employee handbook might not be in compliance anymore. Now, let's say you're a Washington employer and pre-COVID, you had all your employees here working, in maybe downtown Seattle, your downtown Seattle company with 50 employees. And then COVID happened, and well, some of your employees moved to California, a couple of them moved to Wisconsin, you've got some in North Carolina now, and they're all working remote out there, and you're fine with that. Maybe you have a flexible work arrangement policy, and you're fine with these employees living out there. But now you have employees in California, in Washington, in North Carolina, and Wisconsin, and your employee handbook might not be up to code anymore with those other states' requirements. So you have to update your employee handbook every single time you get an employee in a new state. This happens a lot, and employers often don't catch it because they'll have an employee who's working in Washington and then moves and goes remote, and you don't think about it. Well, now you have to make sure you're in compliance with that state's laws. It's not super difficult if you want to have an employee in that state. It's not crazy difficult to change your handbook policies. And what I usually do is I have certain amendments that I add to the end of a general employee handbook, so that way you can insert them when you get an employee in another state. But it can cause problems if you don't catch it. So if you have an employee who's wanting to go remote, it's not the end of the world in terms of cost and getting your handbook compliant with that state's laws. But you need to know what they are, and you need to make sure that they are compliant before they move out to that state. So those are my general recommendations of things that I see when people are putting together employee handbooks that often don't go so well. And if you have any sort of questions, you're wanting to put together an employee handbook, you want to know if yours is in compliance or whether it's satisfactory, or you want my 2 cents as to what you should change, you can give us a call here at 425-776-4100. Ask for me. I'm happy to talk you through any sort of employment issues. And that's going to be it for today's webinar. I hope you enjoyed it. Hope you learned something, and we'll see you for the next one.